Assaults are one of the most commonly filed criminal cases in Texas. An assault can vary from a Class C misdemeanor, which is just a ticket, all the way up to a first-degree felony, which is punishable by 5 to 99 years or life in prison. In this video, we're going to look at what an assault is in Texas, and we're also going to look at effective defenses. In fact, we'll cover 11 defenses that might apply to an assault. You'll find the definition of an assault in Chapter 22 of the Texas Penal Code. Specifically, Penal Code 2201 addresses misdemeanor assaults, and 2202 addresses aggravated assault, which is a felony offense. Looking first at what a misdemeanor assault is in Texas, you'll see that Penal Code 2201 says whenever someone intentionally, knowingly, or recklessly causes bodily injury to another person, that is an assault. So let's first look at the mental state: intentionally, knowingly, or recklessly. Intentionally means you intended to cause that result. You meant to assault. Knowingly means you knew that the likely outcome of what you were doing would be to result in an assault on another person. Recklessly means that you were aware of a substantial risk that the outcome would occur and you disregarded that risk, you did it anyways, and that's how the injury occurred. You'll notice those three different levels of mental states apply both to the misdemeanor version of assault and the felony version of assault in Texas. Next, the misdemeanor version of assault in Texas refers to bodily injury. When you see that term bodily injury, you might expect that it would mean something visible, at least redness, maybe some bruising, some sort of indication that there was actually an injury. Well, the reality is in Texas, bodily injury only requires for the other person to say that it hurt, even if there are no visible injuries. So as we come back and we talk about defenses, we're going to keep that in mind. The misdemeanor definition of an assault doesn't end there, and this is important. It is also a misdemeanor assault in Texas when a person threatens someone with imminent bodily harm or makes physical contact in a way that they should have known the other person would have found that offensive or provocative. So let's break that down a little bit. The first thing we mentioned actually covers an instance where there's no contact, there's no injury. It is simply a threat. And most people don't know that you can assault a person just by threat. And there's a misdemeanor version of this offense called assault by threat. You also have the offense of assault by contact. And here, notice the definition doesn't refer to bodily injury. Instead, it refers to offensive or provocative contact. So in terms of misdemeanor assaults in Texas, you really have two types. First, when you have a person claiming they had bodily injury. That's a Class A misdemeanor. It's punishable by up to a year in county jail and up to a $4,000 fine. Then you have a lower level version of assault in Texas, and that's a Class C misdemeanor. So it's only punishable by a fine, not by jail time. And the threshold requirements are either the contact was offensive or provocative, we call that assault by contact, or the assault was by a threat. And here it specifically has to be a threat of imminent bodily injury. So it's not, hey, I'm going to come beat you up next week. It's, hey, I'm about to kick your ass, would potentially be an assault by threat because it's happening right now. The threat is they would do that in the moment, not sometime in the future. And it is a threat of bodily injury as opposed to some vague or generalized threat. Let's move on to Penal Code 2202. This addresses aggravated assault in Texas. Aggravated assault occurs when a person causes serious bodily injury to another person or uses or exhibits a deadly weapon during an assault. Serious bodily injury refers specifically to injuries that create permanent disfigurement, long-term impairment, or injuries that create a substantial risk of death. So these are different than bodily injury, where there's only a requirement that the person say it caused them pain. Once it rises to the level of, hey, this could leave a permanent mark on them, scarring, disfigurement, we often think about broken bones, surgery, or certainly anything that would create the substantial risk of death. Those would all be considered serious bodily injuries. But again, notice that the definition doesn't stop with what we might again presume would be a felony offense for assault. When you look at the definition for aggravated assault, one of the things that you'll notice is it refers back to the underlying assault statute, 2201. You might call it simple assault. And remember, in that simple assault statute, you have the ability to have an assault that is solely based on threat. In the felony version of that, when you have a threat that is made using that specific phrase of while using or exhibiting a deadly weapon, or the person is threatening to cause now serious bodily injury. Now those threats become felony offenses. So imagine this terrible but somewhat common example. Imagine a couple is having a fight in a kitchen. It's a verbal argument. And in the heat of the moment, while one spouse is holding a kitchen knife that they were chopping vegetables with, says something that could be interpreted as a threat. Well, now you have a threat being made while that person is holding a deadly weapon. That's an extreme example, but you see how that definition is so broad. And again, you have an instance where a person is being charged with an assault, and yet no one was injured. It was simply a threat. And this time, you're being arrested or charged with a felony offense. In my example, that would be a second-degree felony offense of aggravated assault with a deadly weapon by threat. So that's a 2 to 20-year prison sentence and up to a $10,000 fine if you're found guilty or if you plead guilty to this charge. As we discussed at the outset, aggravated assault could even be a first-degree felony with that highest level of exposure in terms of the punishment range. You will typically see a felony assault charged as a first-degree offense when there's a special class of victim. So for example, if the victim was a police officer or a judge, these are ways to enhance the punishment range from essentially the standard second-degree felony of 2 to 20 years and now bump it up to a first-degree felony where you see 5 to 99 years or life as the punishment range. The same would be true if you had a child victim, so someone under the age of 14, or an elderly victim, someone over the age of 65. Let's look at the defenses to assault in Texas. These are just some of the more common defenses. Defenses apply based on the unique facts of each circumstance, so be sure to talk to your attorney about these. But here are some of the more common ones I've seen over the last decade. First and foremost, when you're looking at a defense, you want to see what you can attack in the statute that the prosecutor can't prove. So when you look at the definition for assault or aggravated assault, you see that it starts off with the mental state requirement, that the assault had to be committed intentionally, knowingly, or recklessly. And frankly, recklessly is a low bar, but it does not include all possible contact. So if you accidentally bump into someone, you didn't mean to do that. You did not knowingly do that. And if we can show that you were not reckless about your behavior, then that might be a way to show this does not meet the elements for assault in Texas. So that first way is showing the mental state did not exist for the state to prove their case of assault. When you're looking at assault allegations, you always want to look at the trustworthiness of the person who's making this complaint. Many assaults occur without eyewitnesses. Many assaults are simply he said, she said. And you have to look at the trustworthiness of those witnesses. Have they made prior allegations? Have they themselves committed any offenses, specifically past crimes of moral turpitude that you could use to impeach them? Is there anything else that you can find out about this person that would show they are not trustworthy? Because if the state is building their case entirely based upon a person's word, then the credibility of that person is of the utmost importance. When you think about physical evidence as a way to defend against an assault allegation, for a misdemeanor in Texas, there's no requirement for any physical proof. Nonetheless, depending on what's being alleged, you can absolutely point out the absence of evidence. It's not the be-all and end-all to have a lack of physical evidence, but it can certainly be a strong point. Of course, this is not going to apply directly to assaults by threat, because there it's not an allegation that there was any contact. But when you get to a felony contact offense, so aggravated assault with a deadly weapon, for example, you are going to expect to see some physical evidence. First of all, if there's an allegation, even of a threat, that a deadly weapon was used or exhibited, well, then there needs to be some evidence that that item actually exists and was there at the time. Similarly, if there's an allegation that the assault caused serious bodily injury, then there's absolutely a threshold requirement for the prosecutor to prove the injury was actually serious bodily injury as opposed to bodily injury. And there are times when we will get an expert opinion on, was that serious bodily injury or was it merely injury? So you might think of an example where there's an assault, someone is left with a black eye. Well, does a black eye meet the definition of serious bodily injury? So that definition we refer to for serious bodily injury comes from Penal Code 1.07. Serious bodily injury is an injury that creates a substantial risk of death or causes permanent disfigurement or loss of a function. So a black eye, although some might consider it serious, is unlikely or almost certainly not going to meet the definition of serious bodily injury. So pointing out the lack of physical evidence is certainly one way to point out deficiencies in a state's allegation that you committed assault. Another way to overcome an assault charge is to look for forensic evidence. These days, it's seemingly impossible to go anywhere where you are not on camera or there's not some device recording what's going on. One of the things that your attorney can do is ask for shop owners or barkeepers to keep the video that they've recorded and then to obtain that video. You might have an investigator canvass a neighborhood to get Ring camera videos or doorbell videos. Forensic evidence is often a powerful way to overcome the state's allegations. The more serious the case or allegation, the more time and energy can be spent in finding key pieces of information. We've seen murder cases where a key piece of defense evidence came from in-home recordings, like Alexa on an Amazon device. Another aspect of defending an assault charge is getting witness statements. If there were other people at the location or in the immediate vicinity of the location of where the assault is alleged to have occurred, then those are statements that we will probably want to get. Of course, if there were eyewitnesses of what occurred, it's a no-brainer. We'll want to go out and talk to them. But if it is a person who was in the vicinity, maybe someone who was in the home, in another room, the things that they did not see or did not hear might be key pieces of evidence in defending you. Self-defense, of course, is an important and affirmative defense that you can raise in Texas. Self-defense doesn't apply just to yourself, it can also extend to others. And here you have to show that when you were using self-defense, you were not committing any other offense, you weren't the aggressor, and that you were responding in a reasonable manner based on the threat that you perceived. Affidavits of non-prosecution can be powerful tools, but again, they're not the be-all and end-all. An affidavit of non-prosecution is a victim swearing that they do not want this case prosecuted. Sometimes that statement is not worth the paper it's written on, and sometimes it has some persuasive value with the prosecutor. Don't expect in most major counties for a prosecutor to simply dismiss a case just because that's what the victim wants. Prosecutors look at the world a certain way, and they become somewhat callous to these affidavits of non-prosecution because they get them so often. They are just pieces of paper that go on the file, but they can be useful tools if your attorney knows how to use it correctly and if you have an open-minded prosecutor on the other side. It is often one tool that is used as opposed to the only tool that is used in overcoming an assault charge. Another way to overcome an assault charge is the idea of consent or mutual combat. Sometimes that consent is implied. So for example, if you get on the football field, you know you're going to get hit. You can't claim that you were assaulted under normal circumstances on the football field. Of course, if there's something that goes beyond the actual sport, then that could be an assault. So consent could be, hey, we're going to go have a fight. Let's take it outside. That's consent. You've agreed to get into that fight. Another way to describe that would be to say it was mutual combat. We knew what we were doing. We both got into it knowing we were going to get hurt. And now the person that was hurt more can't turn around and say, hey, I was assaulted. Another key way to have your assault case dismissed is through what's called prosecutorial discretion. And this goes back to the idea that we are often doing many things to get a case dismissed, not just relying on one thing. So it's not uncommon for us to go in and talk to a prosecutor, point out one or two things that might be a weakness in the prosecutor's case, and to also give the prosecutor some things to think about. It may be a mitigation packet talking about all the good things my client has done with their life. It might also be things that my client has done after they were arrested for this assault. And that can be valuable. It's not an admission of guilt to go out and work with a volunteer organization. It's not an admission of guilt to take an anger management class, because we know these can sometimes be tools that a prosecutor can look at and say, well, I have mitigated the risk that this person is either an offender or would be a future offender. They have no criminal history. They've done a lot with their lives. They've done a lot since they got arrested. What's the real purpose of convicting them or sending them to jail. It may not work as well on a felony, which we're going to address in a moment, but it can work very well on certain misdemeanors, particularly on non-family violence offenses. So let's cover those two exceptions. First, the family violence offenses. One of the ways that a case might get dismissed is through a diversion program. Many district attorneys in the state of Texas have come up with certain diversion programs where if you're accepted into the program and you complete certain steps, your case could ultimately get dismissed. And so based on what jurisdiction you're in and the nature of your case, that's something you'll want to talk to your attorney about. We also talked about the fact that a felony case is unlikely to get dismissed just based on mitigation. But what you can do in a felony that you can't do in a misdemeanor is put together a grand jury presentation. This is also going to depend on what jurisdiction you're in. But a grand jury presentation means before the case is indicted, which is a necessary step in a felony prosecution, you can put together a packet and present that either yourself or by submission to the grand jury. So when the grand jury is back there trying to determine if this case should go forward or not, they have some materials to look at. Now, the grand jury only has to find that there's probable cause to proceed. So you really want some strong evidence, such as they can't prove an element of their offense, but you need to couple that with, once again, mitigation. So it's not that mitigation or work that's been completed after an arrest doesn't matter. It's got to be combined, particularly in a felony case, with significant weaknesses in the case. Those are just a handful of ways that we've gotten assault charges dismissed in Texas. We have offices in Fort Worth, Dallas, Southlake, and Houston. If you're facing an assault charge in any of those cities or surrounding areas, just look for Varghese Somerset on the web or any social media site. You can also call us at 817-203-2220.